Good morning, everyone. Hopefully you got your cup of coffee with you and you can hear me okay. Please let me know down in the comments. Today we're talking some case law. Just recently we had, just on Friday, a new opinion was released out of South Florida. It's a county court opinion, and the county court judge is explaining how the new facts from the United States Supreme Court in the Bruin opinion, he circumvents the Bruin opinion and ruling that a statute prohibiting convicted felons from carrying firearms is illegal. And so, hey, good morning, Doc. Hey, good morning, everyone. Today we're talking case law, and what we're talking about today is out of South Florida. A recent opinion was released regarding firearms. It's all surrounding the Supreme Court's decisions and related concealed carry that's come out lately. In particular, this opinion is in Bruin. And then I've added a link to the case that we're going to be reviewing down in the description. There's a link to a Google Drive folder. Yeah, get your concealed carry permits, what the captain says. I definitely agree with that. There's several benefits. So, Florida is now a permitless carry state, but, there's certain circumstances, maybe such as going to church where your church has a school within it that, if you don't have a concealed carry permit, you're committing a felony. Or I think that'd be a felony version of it because that federal law. Same thing we've talked about on this channel before, where if you're driving through a school zone, that's technically a violation of federal law if you have a gun with you, but it's not a violation of federal law if you have a concealed carry permit the way the law is written. Because the federal law says that if you've gotten a background check from the state and the state has given you a concealed carry license, at that point in time, you're exempt with regards to carrying in the school zone. So yeah, pretty good advice there. Get your concealed carry permit. Costs $100. Good to go. Ready to learn for the weekend. Yeah. As I get older, it's all about learning. Right now, I'm all about transparency in the government and just being on the inside of it. I used to track my arrests that I'd make, and I'd track my entire squad's arrests. And I was trying to formulate if you could make any sense out of, if we made a certain amount of arrests in this area or this region, would we see any impact in like number of crimes or life savings or something like that, or reduction in accidents in the DUI days. And so I've just always been a student of realistic data, meaning like looking at arrest stats and comparing it. I've always like plotted out on a map. And so we're talking about learning on this weekend. And that's what I'm doing right now is I'm plotting out all this arrest data, and I'm trying to figure out a way that I can sell it. Not necessarily you guys as like a channel. You guys are just citizens that are interested in learning, but certainly there's business aspects of this that could be applicable. I run my law firm off of business data. And so I think other law firms are in that as well. And so if I can do a dual part service of, making money through this, as well as providing government transparency, then that's what it's going to be. And that is me learning Power BI. So I'm seeing a lot of familiar faces in here. I'd say it's all gentlemen. I think we only have one or two females that come in. Generally speaking, this channel is like 99% men, but if you're the female in the room, or if you identify as a she, her, is that what you say? What are your pronouns? God. So talking about pronouns, yeah, I'm kidding there because I definitely wouldn't say that. DeSantis has pissed some people off in my community. He posted or ousted that the state attorney in Orange County. It caused a lot of trouble. And so he's appointed someone that's a little bit disturbing. You may have some thoughts on that. I don't know. Any thoughts on that? You can take those. So good morning, Joe. Good morning, Ray. Men to learn, men to like to learn. Case law is slave law. All right. Yeah. I don't know. I guess I don't know what I mean by that, or what you mean by that. But so let's jump into this a little bit. So what we're talking about here is, let's just get in. We're talking about the state of Florida versus Montano out of the 11th Judicial Circuit and for Miami-Dade. Okay, so what does this tell you? So this tells you that this is not a district court of appeals opinion. In Florida, we have multiple levels of court. We have the trial court. And at the trial court level, we have the county court, which handles all the misdemeanors. And then we have the circuit court, which is the trial court for felonies. And then above that, we have the district court of appeals, which is the appellate court. And then above that, we have the Florida Supreme Court. And so this is a trial court level, and the trial court judge has been presented with an argument by attorney Milton Hirsch. He's a big name, or Hirsch is a big name judge down in Florida, South Florida. And the motion here is the defense attorney is trying to use the current Florida or current United States Supreme Court opinions and jurisprudence, particularly in Bruin, to establish that Florida's law prohibiting convicted felons from carrying firearms is illegal. It's unconstitutional. And the Bruin opinion is really housed, that's the United States Supreme Court opinion. The Bruin opinion is really housed in this idea that we've got to protect the Second Amendment. It's not a secondary right. And that the only thing that can disrupt the Second Amendment right would have to be a long-standing historical tradition that was around at the time. And so the arguments the defense attorneys are making right now is, well, listen, juvenile law and, you know, at the time, stealing $300 worth of stuff or $700 worth of stuff wouldn't be called a felony. So these laws, since there's no long-standing tradition of this theft law being a felony, therefore you can't take someone's Second Amendment right for a non-violent felony. And so that's kind of the underlying argument, and the judge lays out his opinion why he doesn't agree with that. So he's arguing that the statute is not felons and possessions. Order on defendant's motion to declare the Florida's felony and possession statute unconstitutional. And surprise, surprise, he's going to declare that the statute is constitutional. Good morning, Doc. So yeah, I used to track all the calls. So yeah, I think Doc, I think it used to be EMS, right? Something like that, paramedic, somewhere in there. I'm not sure where that line is divided between EMS, paramedic, and whether you're working for an ambulance company. But I was paid armchair quarterback. My wife listened. Okay, got it. Excellent. All right, wife's listening in, so we do have someone. All right, got some females there. So all right, so let's talk about this. So he's giving the opinion. In the year 2023, library shelves groan under the weight of the statute books defining the hundreds and hundreds of felony crimes. But it was not always so. At common law, there were but 9 felonies. Now, what does it mean by at common law there? At common law means that before there was actually statutory law, we pointed back to the laws of England where we came from on the boats. So the boats came here and the English system had these set laws in place, and they were relatively simple and they were established all by the courts. And so we adopted those at common law, and that then became formed into case law and formulated along the lines. And we have statutory law, common law, and case law now. So what it's saying is, you know, when we start off, you could fit all the felonies on one page, and now we can't even fit it all in a library. So the penalty for conviction back in the day was frequently death, and thus in the year 1791, when the Second Amendment was enacted, there was a relatively small, likely a very small population of convicted felons, persons who committed one of these very few felony crimes that were still living. So the argument here is back in the 1790s, 1791 is the year Second Amendment came into place, was enacted, that, okay, convicted felons weren't really a thing then. So weapon of choice for Minutemen, those once embattled farmers, was the musket. It was like, so you see where we're going, right? He's obviously going to be attacking the AR-15. We're laying that foundation out right now, right here. As soon as you start introducing muskets with, inaccuracy, we're going to start talking about AR-15s and how fast and deadly they are. So get ready for it. So weapon of choice, the Minutemen of those days was musket. Hey, Rex. Here. So I got the dog here with me. I don't know if you say hi. You say, ooh. I don't know if you say hi. That's too much. All right. Probably annoying for you guys anyways. But anyways, me and Rex went for a run this morning. So we got embattled farmers. Even one skilled might get up as many as 2 rounds per minute. without much accuracy. The weapon of choice for most American present-day mass murderers is the AR-15, and even without a bump stock, can fire about 60 rounds per minute. And he's citing in different places how tragic history of mass shootings from NPR, what makes the AR-15 style for weapon of choice for mass shooters, CBS, worst mass murderers, blah, blah, blah. So we got all these things. All right. So he, after citing all those sources, it is the thesis of the motion at bar that the Second Amendment, when enacted when convicted felons were few and by today's standards, and firearms not particularly dangerous by today's standards, renders absolutely unconstitutional Florida's long day present prohibition on the possession by Florida's many convicted felons today's frighteningly deadly firearms. Okay, that was a lot. That was a lot to swallow there. So let's back up on that. So it is the thesis of this motion. So he's saying, hey, the defense attorney in this case is arguing that the Second Amendment, and he added his own little sections here, extra stuff. So we'll skip over that. The Second Amendment renders absolutely unconstitutional Florida's prohibition on the possession of Florida or firearms by convicted felons. So now that's all he's saying, is that the current law is unconstitutional. The judge here adds in his own flavor of, particularly dangerous firearms and absolutely, and all these extra words in there to make it sound a little bit more, poetic, I guess. So the people of the state of Florida, their duly elected legislative representatives, in enacting and maintaining the statute books for decades, a prohibition against the possession of firearms with those convicted of crimes, often of violent, dangerous, and have, according to the pending motion, acted in flagrant disregard for constitutional limitations. So the judge here is kind of attacking the defense attorney's position, because I guess the defense attorney's motion says, listen, the law has always been unconstitutional, and now it's been locked in that it's been unconstitutional. And so therefore, court, you've been acting all this time in flagrant violation of the Second Amendment. And the judge is kind of giving the middle finger there, saying, screw you. We've been looking at this for a long time. Everybody's been doing it across the board. And it is not what you're making it out to be. So there we go. I respectfully disagree. So, okay. So now he's going to go into the analysis. So he's laid out the argument here. The statute is unconstitutional based upon these Florida Supreme Court opinions. Let me go to the comments here, hang out with you guys for a second. Okay, so paramedics the highest. Oh yeah, so we got the EMS and paramedic levels. Second one is clear. Case laws, way the governments muddy the waters to get around the limitations. Yeah, so hey, referee, that's a really good point. He's actually going to dive into here. I skimmed through this opinion, and he's going to break down how he structures the Second Amendment and the reading of it with a preparatory clause and then an operational clause. So I don't know if we can hang tight for the whole time. We should be getting that here in a few minutes. If I knew I was committing a felony, then I knew the consequences. No good for you. Yeah. Well, what's so strange, though, is we've got so many felonies on the books. I dare say that most of you probably committed a felony in the past couple weeks. So, I mean, that gets pretty crazy. So I'm not saying that you guys are all bad dudes or anything like that, but I think the lines get really blurry on where we're at. So let's talk about mass shootings and the government. I think we already said that. Judges want the UN, Russian military money, Sean. So here you go, Sean. If you do your time, you should be fine. Problem is most felons are often repeat offenders. Yeah, so that's a pretty dangerous slippery slope there, I guess. I'm not necessarily of the opinion that convicted felons should be able to possess firearms. I don't believe that, according to the law, that they're people. So, and obviously I have no problem with convicted felons and as people, but from a legal standpoint, I think people from a historical concept was intended to be those who intended to vote. And so I think there's a disconnect there. But anyways, that's neither here nor there. Let's get into this analysis because that's what's important. Our opinions don't necessarily matter. It is what the law says. So for nearly half a century or century and a half from the time of enacting the Second Amendment, the federal government felt no particular obligation to regulate trafficking firearms. So for nearly a century and a half from the time of the enactment of the Second Amendment. So 1791 to the 1920s, which we gave rise to prohibition and bootlegging, giving rise to many shootouts. Al Capone's boys machine gunning Bugsy Moran's boys in Clark Street Garage in Chicago on Valentine's Day. See the St. Valentine's Day Massacre on Wikipedia. Okay. So the crash in 1929 gave rise to the Great Depression. The Great Depression gave rise to Tommy gun toting bank robbers such as John Dillinger. See government history here and all these things. Jack Miller. Okay, so he's saying that there was no regulation until the 1920s. And what do you know? So is it strange there that we don't we don't have any gun violence until the government enacts prohibition? So we're all fine, no need to regulate firearms, and then the government enacts a law which restricts what we can drink. Prohibitions like the prohibition of alcohol. They made alcohol illegal. So then we have the prohibition, which then the result of prohibition is Al Capone and Bugsy Moran's boys in a shootout. So, yeah. Then we had the Great Depression. Once again, another government act giving rise to bank robberies. Anyways. So Jack Miller and co-defendant were charged violating this act. So we got the National Firearms Act enacted in 1920, June 24th, June 26, 1934. Now we got a case law that's going to be argued about this. And right now we're talking about the history. Remember, this judge is given his analysis of where we're at. So what we're talking about, we're reading a court's opinion on the constitutionality of Florida's felons in possession of a firearm. This is the judge's opinion. And in the introduction, the judge laid out what he was arguing and what he was going to put in the motion and how he's going to debate it. Now we're going to the analysis. The judge is laying out right now a historical timeline. And this is going to be really important because one of the references in Bruin, the Florida or the U.S. Supreme Court that's been recently decided, is that if you're going to challenge or create a law that infringes upon the Second Amendment, then it has to have some long-standing historical context in United States history. And so the judge is making that argument here that in the 1920s is the start of this. So Jack Miller and co-defendant were charged with violating the act by interstate transportation of a sawed-off shotgun. United States versus Miller, Supreme Court case. A duly imposed demur alleged that the National Firearms Act offends the inhibition of the Second Amendment to the Constitution. Justice Reynolds, writing for an all but unanimous opinion for the court, undertook what today was described as an originalist approach. An examination of the original intent. He carefully considered the text of the Constitution and the Bill of Rights, a number of state legislative enactments made contemporarily with the documents and the commenters upon whom the founders would surely have relied, such as Blackstone and Adam Smith. Based upon that survey, the justice had no difficulty concluding that in the absence of any evidence tending to show that the possession or use of a shot-off shotgun having a barrel less than 18 inches in length at this time had some reasonable relationship to the preservation or efficiency of a well-regulated militia, we cannot say the Second Amendment guarantees the right to keep and bear such an instrument. Okay, that was a lot. I get it. I appreciate that you guys are hanging tight with here because this case law is not necessarily easy to read and it takes some work. So we're breaking this down paragraph by paragraph. So the court is laying out here that in 1939, the courts have already looked at this and they looked at the issue of whether the possession of a shotgun less than 18 inches tended to show that there was some reasonable relationship to the preservation or efficiency of a well-regulated militia. And they say in this case, we can't say there is. With obvious purpose to assure the continuation and to render possible the effectiveness of such forces, i.e., citizen militias as they existed at the time of founding, the Declaration and the guarantee of the Second Amendment were made, it must be interpreted and applied with the end in view. The sentiment of the time strongly disfavored standing armies. The common view was the adequate defense of the country and the laws should be secured through militia. Civilians, primarily, soldiers on occasion. So, I mean, we've heard this argument before. I'm sure this is common day talk with against the Second Amendment that at the time people were intended to be militiamen. We don't have a need for that anymore, so therefore it doesn't necessarily apply. Okay, let's skip through here a little bit. So in here, the sense of the foregoing seems plain enough. And it was the law of this land from 1939. So it's saying, hey, this came about in 1939, and we've gone this way ever since the Prohibition days. We said a sawed-off shotgun was illegal. And until 2008, everything was fine. What happened in 2008? Leave a comment in there if you know. It's on the screen somewhere. You can read it. So 2008, there was a major landmark decision that came out that changed the whole framework here. And I'm sure you'll know it once I mention it. You can read it on the screen, but this court is pointed to that 2008 opinion as the game changer, and it doesn't like it. Okay, so that opinion was Heller. That's what changed in 2008 was the opinion in Heller. So if we were to pose this question, if there's any rule of constitutionary interpretation that has been universally endorsed from the dawn of our jurisprudence to present day, endorsed without regard for party affiliation or jurisprudential school of thought, the answer would be yes, there is one. So once again, the judge is blowing up some like impressive language here, but he's just saying that ever since the beginning, everybody can agree that there's one thing everybody agrees on, and it's this. The rule is that the Constitution is to be interpreted as a whole, and that no passage of the Constitution is to be dismissed as mere rhetorical flourish or a prosodic device. That changed completely in 2008 with the promulgation of Heller. So it's saying that this whole idea of jurisprudence, like the understanding, the study of law and the understanding of law, was consistent forever. And then the Heller opinion turned that on its head. Heller proceeded from the premise that the Second Amendment consists of merely a prefatory clause. This is what we're talking about. Somebody mentioned earlier, weren't following along, didn't understand what's going on. This is the core of it. So we have the subjective, we have an interpretation issue here. And so Heller says that the Second Amendment is divided into two different parts. The prefatory clause, which is imperative but rhetorical. You don't really got to look at it. And they're saying that part is a well-regulated militia necessary to the security of a free state. So that part is just kind of like modifier, doesn't need to be applied in this judge's opinion. No. In the Heller opinion, that's what that said that. And then there's the operative clause, which is the key clause that needs to be focused on. And the right of the people to keep and bear arms shall not be infringed. And that's kind of what Heller says. And the court here says, if that's true, the first dozen words of the Second Amendment are only genuinely inner language appearing anywhere in the Constitution. Then, of course, Miller, in every post-Miller case, the entire existing Second Amendment jurisprudence was wrongly decided. The Heller court then proceeded to tear up the Heller court proceeded to tear that jurisprudence up root and branch. All right, let me break that down a little bit. So the court started off on let's start from the beginning. So we're talking about the constitutionality of Florida's in possession. The court gave their opinion. We're talking about Judge Richard Hirsch out of Miami, and he's talking about the Minutemen, and they didn't carry rifles. They only carried muskets and couldn't fire guns so fast. And that, then he pointed to that this new opinion in Bruin talks about historical traditions, and that the Heller opinion changed the longstanding position from 1934 that you couldn't carry a sawed-off shotgun to now it's a two-part analysis of the Second Amendment. So that's where we're at. We just did the two-part analysis of the Second Amendment. It comes up in Heller. The first is the prefatory clause, and the second is the operative clause. Okay. Although the Second Amendment does not protect those weapons not typically possessed by law-abiding citizens for lawful purposes, neither the Second Amendment nor Heller tells us exactly what type of weapons are typically possessed by law-abiding citizens for lawful purpose, or how to recognize such typical possession. Heller is not restricted to the right to keep and bear muskets. Does it extend to the right to keep and bear AR-15s? Cites to CID. So that means C previous at 582. So what's the previous one? So it's C, the Heller opinion at line 582. The Second Amendment extends prima facie to all instruments that constitute bearable arms, even those that were not existent at the time of founding. Second Amendment extends at face value. So this is important. This is an opinion out of Heller. This is a statement out of Heller. The Second Amendment extends at face value, that's what prima facie means, to all instruments, so all tools that constitute bearable arms. So I guess what does that word bearable mean? Like presentable, carryable? So that would mean like maybe a tank would be out, but not necessarily, is it? Yeah, what's that word bearable mean? Somebody Google that and type that into, I don't have time to Google it while I'm on a live stream, but somebody Google that and type that into the chat box. All right. What Heller does tell us is that nothing, in our opinion, should be taken to cast doubt on the long-standing prohibition on the possession of firearms by felons. Okay, so this is a valid point. So the criminal defense attorney in this case is talking about, the criminal defense attorney in this case is suggesting that, according to this new provision, there is no long-standing prohibition against convicted felons possessing firearms because convicted felons weren't really a thing back in the day. So therefore, the law should not prohibit convicted felons today. But the judge here points to Heller and says, hey, as crazy as Heller is, turning everything on its head, even Heller tells us that it doesn't stop people from possessing firearms, the long-standing prohibition on possession of firearms by felons. So 2 years later, McDonald v. City of Chicago, they applied Heller to the states, to the 14th Amendment. So what does that mean? The federal government, the Bill of Rights, the first 10 amendments, the Constitution only is a negative rights document. It just tells the government what it's not allowed to do. And that tells only the federal government, because we're supposed to be a states' rights country. The testing grounds are the states. And so the federal government has very few powers that it can enact. Now, through the Commerce Clause, they've expanded that out. But originally, the federal government was not supposed to have a lot of power. In fact, that's the Articles of Confederation. We started off with the Articles of Confederation, and the reason why the United States failed under the Articles of Confederation is because there wasn't enough structure. There wasn't enough rules. They made it so loosely bound that it wasn't enough to sustain government. The government couldn't tax. They couldn't form, there's a bunch of stuff the government couldn't do. They said, well, it's just a big pile of mush. We can't do anything with it. So we need to form something a little bit better. And they came up with the Constitution. But they just moved the ball a little bit further down the ability to enforce laws. And now we've just continually been moving that over and over and over and taking on more and more rights. All right, so let's see if we got anybody with some definitions here or anything in the comments. See, arms should also cover blade. That's interesting. Now Fairgrounds asks, what? Yeah, make it up as we go. All right, 14-inch, all weapons are covered, would be arms. All right. Let's keep going. So 2 years later, McDonald, the opinion in McDonald, they applied the Heller opinion to the second opinion and Heller opinion to the state laws, meaning states can't regulate firearms as well. So the McDonald court rehearsed with emphasis the words from Heller. So what it's saying in here, McDonald, which applied the Second Amendment to the states, then used the words from Heller and said, we made it clear in Heller that our holding did not cast doubt on such long-standing regulatory measures such as prohibitions on possession of firearms by felons. We repeat these assurances here. Thus, as late a dozen years ago, it was clear that state laws could, without infringing on the Second Amendment, incorporate via the Second Amendment, prohibit possession of firearms by convicted felons. So the judge here is saying, listen, Mr. Defense Attorney, you're the one trying to change the rules here, because until from 1930s all the way forward till right now, until Bruin in 2022, the law was pretty solid that states could regulate on the possession of firearms by convicted felons. New York State Rifle versus Pistol Association versus Bruin, which came out in 22, is the Supreme Court's latest pronouncement on this subject, and one upon which the defendant relies entirely. So the defendant is bringing his case after Bruin. A ton of people are. There's a ton of stuff going on with Bruin right now. For the present purposes, the facts of Bruin are of little consequence. What is of consequence is the court's treatment of the Second Amendment. It would perhaps be more accurate to refer to the court's treatments, plural, of the Second Amendment issues. Justice Alito's crucial concerning opinion, as well as the opinion of other justices, seem to point in one direction. Justice Thomas's opinion for the majority may or may not point in a different direction. Okay, so what's he saying here? This is a little bit strange. So when you have an appellate body of courts, there's multiple judges that are sitting on it. And even if you have, 6 or 7 justices sitting on a body to review some law, review a case, not all of them are always going to be sitting on every case. They may be on vacation, or maybe for whatever reason have some type of political connection, so therefore they have to exclude themselves, or they may be sick. Who knows? But for whatever reason, not all judges are on all the cases. The judges all argue these cases or hear the arguments on these cases together, and then one of the judges is assigned to write the opinion. And he has a whole staff of attorneys, I'm sure, or he or she has a whole staff of attorneys that then write the opinion for them based upon the arguments and the structure laid out by everyone else. Well, the other judges get the opportunity to read the majority opinion, is what they call that. The person assigned to write it writes the majority opinion. And if the judges that are also in agreement don't like exactly what that judge says, they can write their own opinions. And so that's what this judge is talking about here. So the opinions other than the majority opinion. So you got these other judges who are agreeing with the opinion of the court, but have wrote their own kind of analysis. The majority opinion in Bruin is lengthy and far-ranging. In his concurrences, Justice Alito, the author of McDonald, so this is the Supreme Court justice that wrote the opinion in McDonald, seeks to make clear that Bruin is intended as a step forward in the same direction taken by Heller and McDonald, not a what is that? D-I-V-A-G-A-T-I, divagation? I don't know what that word is. So from that path. So it's not a deviation from that path. Today's decision holds that a state may not enforce a law that effectively prevents a law-abiding residents from carrying a gun. That is all we decide. Our holding decides nothing about who may lawfully possess a firearm or requirements that must be met to buy a gun. Nor have we disturbed anything that we said in Heller or McDonald about restrictions that may be imposed on the carrying of guns. So the court is holding here that, there is still some ability to restrict, but the Bruin opinion doesn't seem to suggest that. Okay. So he cites the concurring opinion here. I read it all the way to side in this case. The Second Amendment protects the right of law-abiding citizens to carry a gun, blah, blah, blah. Got it. We have another Justice Kavanaugh saying the same thing. If this is the extent of Bruin, the motion at bar is easily disposed of. The Florida statute under attack prohibits the possession of firearms by those, as a matter of tautology, are not law-abiding people, but are felons. According to Justice Alito, Justice Kavanaugh, and Chief Justice in concurrence, and Justice Breyer, Justice Sotomayor, and Kagan in dissent. Heller and McDonald make clear beyond pre-adventure that states remain at liberty to take firearms out of the hands of such persons. Okay, what do you think about that? So we have the courts here discussing the opinion. Do you think convicted felons should be able to possess firearms? I guess that's the first question. Or should there be a separate test? So not non-violent convicted felons. So if you got convicted of tax evasion, but you could, but if you got convicted of, robbery, you couldn't. Where do you draw the line there? Is there a violence component? Yeah, we'll go back to this in a few minutes. Let's see what Joe has to say here. Let me flip you up on here, Joe. So I believe that everyone who decides to carry a gun must have to take basic gun safety course. They should at least understand what carrying a gun involves. Yeah, that's a good point. But I'll tell you what, Joe, I don't necessarily agree from the standpoint that Florida's law, which previously required you to attend the classes to get the concealed carry permit, I guess you still have to. It was a joke. Like, you got to take a 2-hour class. My dad got his concealed carry permit and he never left inside of a building. He took a 2-hour class and then walked over, and they had like a painter's bucket with a bunch of phone books in it. And he shot a .22 pistol once into the phone book inside a real estate company, and they gave him his concealed carry permit. So to say that you should have training and stuff like that, yeah, great, but we've never really had that. So yeah, it's complicated. I think the default position is probably pretty strong that convicted felons probably shouldn't be able to carry. They do have the ability for them to restore their rights, but it's my understanding that that's really not a meaningful process. They got 50,000 people in line trying to restore their rights to carry a firearm, but they're only processing like four applications a year. And so, anyways, what are we gonna do? Sean, nonviolence. Yes, violence, stay out of trouble, get expunged, and they're good. Well, so there you go. You can't get it expunged. So if you're a convicted felon, you can't get it expunged at that point in time. Because once you have any type of conviction, you're done. You're set in stone. You're convicted of a criminal. You can't have your record expunged. I'll explain that briefly. So let's say you get arrested for DUI. And you hire me, and we fight your DUI, and I get your DUI dismissed on some type of technicality. At that point in time, you could have your DUI expunged from your record, meaning it's completely erased. That's all predicated based upon the idea that you don't have any other convictions. If you had a conviction for possession of marijuana from years ago and you got the new DUI, even though I get the DUI dismissed, you can't get it expunged because you have a prior adjudication on your record. So once you have the adjudication, you're set, or you're stuck. Now let's change that facts around. So you get the DUI arrest and you hire me, we fight the case, and I don't get it dismissed totally, but I get it reduced to a reckless driving, and the court withholds adjudication. At that point in time, you can't have your record expunged, but you can have your record sealed, meaning they close it off so nobody can see what's in there, but it's technically not expunged. Let's see what we got here. Let them keep them, have them for self-defense, maybe. Yeah. Training education should be done by parents. My son did need some crappy classes. I taught him. Yeah. Back in my day, I guess I'm 46. I think I was in the last generation. I grew up outside of Flint, Michigan, and we had gun racks in our house. Like, that was a thing on the wall that we had. And we had a shotgun on there and a couple rifles, and it had 4 racks. And I don't think I ever had a gun rack in our trucks in our car. But it wasn't uncommon to have a gun rack in the back of a pickup truck, back window of a pickup truck either. So Let's see what we got here. Some more. Morally, we should be real trained to carry. However, we believe it would be dangerous. Yeah, I don't know. So from a law enforcement standpoint, they put you through a intensive, 2 or 3 week training, 2-week training session in Florida on firearms, and then they incorporate firearms training live fire throughout the academy, and then twice a year you go to the range and you requalify. And I've done, as a big tactical guy back in the day, and I've done a lot of reading on the psychological impacts of killing and Dave Grossman, a lot of things like that. And they say from a training standpoint that once you have a core fundamentals down of firearms, that it takes about training to maintain the proficiency of what a traditional police officer should maintain or have. Orange County Sheriff's Office, they encourage you to go out once per month. They would give you a box of ammo and then allow you to go to the range to train. So think about all these children 18 years old out carrying guns, have no idea what they're doing. Yeah, that's a really good point, Joe. Last week, the live stream from last week got taken down. YouTube said I violated their cyberbullying policies. I'll explain that here in a few minutes. But the live stream got taken down, and in that live stream, we reviewed an arrest report that was the city of Orlando. An officer that I think is pretty squared away, used to be a former state trooper, and he was in a parking garage and made an arrest of some guys with an AR-15 pistol. And these kids were all 18, 19 years old, and they had 3 guns in the car, smoking weed, and they're not from the local area. So they're from 45 minutes away. They're from Ocala. We got somebody here from Ocala. Who is that? I can't remember which one of you guys from Ocala, but I think we got somebody from Ocala reaching out. Was that you? Did you get arrested those guys in the parking garage? Anyways, we got these guys from Ocala coming into Orlando, all young guys. They're coming strapped to the teeth with legit firepower. And now we've already got a violent situation downtown Orlando. So it's, I don't know what to make of that. It's a complicated problem. It is definitely a complicated problem. So, Caveman Show, it was time gun safety classes were taught in school. Yeah. I don't know if we can go back. I am so disheartened by the school system right now, but that's another topic. So, all right, let's go back to this case law here for a minute. We'll talk about this briefly, and then we'll probably wrap it up here in the next few minutes. So he goes through and he explains that he doesn't necessarily agree, and that the opinions in Heller and the opinion in McDonald state that the prohibition against possession of a firearm by a convicted felon is still constitutional. And he says, until I'm told otherwise by my betters on the Court of Appeal, I decline to believe that it is what it is intended by Bruin. When all is said and done, common sense must not be a stranger in the house of law. If I'm mistaken, at least I'm not alone. Defendant's motion to declare Florida's felony in possession statute, Florida Statute 790.23, is unconstitutional. As unconstitutional is declined. So there we go. Let me go back to main screen here, just me. So this is what we got to be ready for. That's the argument that's going to be made against us in all of our Second Amendment. That musket argument we see come up all the time. You need to kind of be prepared for these. You need to kind of think these through. They got the musket argument here. We have the he's arguing the preparatory clause of the Second Amendment as interpreted by Heller opinion is not applicable. So there's a few things here you're going to see over and over again. Oh, what do we got, guys? I'm wrapping it up. Look through the last questions. Hey, Sean, 53, had a rifle club. Yeah, it's a good question on how old you guys are. This channel, we got, 15,000 subscribers or something like that, 17,000 in that neighborhood. And on my analytics, it's all old guys like us. And so it's so strange, like all these 50, 60, 70-year-old guys all interested in learning the law. I guess there's a lot of misinformation out there. So good. We need more strong men, and I really appreciate you guys taking the time to educate yourself and help me get educated because you hold me accountable. So we'll see you next week, and thank you again for your support. Have a good one.